Great. Welcome back to the House Healthcare Committee. We are still on S37 and we are moving to sections 10 and 10A. So we have Rick Masters, legal counsel of the Interstate Medical Licensure Compact Commission. So welcome. And if you can just introduce yourself for the record, just tell us a little bit about who you are and where you are, and then go into your testimony would be fabulous. Thank you.
I'm Rick Masters, and I'm the legal counsel for the Interstate Medical Licensure Compact Commission. I have also been a drafter of this compact and many others in the healthcare field. For over 20 years, I was general counsel for the National Center for Interstate Compacts. And I guess I should say I'm guilty of being an expert in compact law because I've written the largest treatise on the subject of interstate compact law that is published by the American Bar Association. So I think I have the credentials to give an opinion.
Great.
And I'm here to do that with regard to these sections of the bill.
Great. Thank you for that. And please continue.
Okay. As I understand it, the purpose of the bill is to require Vermont's representatives to any interstate compact commissions, which would include the Medical Licensure Commission, to seek an amendment or exception to the compact or the language of it or the rules or the bylaws as necessary, so that if a licensee is disciplined by another state solely for providing or assisting in the provision of gender-affirming healthcare services or reproductive healthcare services, that it would be legal and meet professional standards if provided in Vermont, and that the compact would not require that Vermont take professional disciplinary action against the licensee. I've reviewed the legislation. In my opinion, the legislation, particularly these sections, don't conflict with the Interstate Medical Licensure Compact because the compact statute already sets forth the primary principle that a practitioner, a doctor practicing under the compact, is required to follow the scope of practice in each jurisdiction in which they practice medicine, which of course includes Vermont. It's also my opinion that because the compact already recognizes that the scope of practice for medicine is sacrosanct, if you will, so that you can't discipline someone in Vermont for rendering a treatment or a procedure that is consistent with the scope of practice. We have also made a amendment to our compact rules that make it clear that a member state is not required to discipline, in fact, should not discipline a practitioner who is practicing under a license issued pursuant to the compact, should not be disciplined for complying with the scope of practice within Vermont, and that they're protected from that and you are not required to do it. So in my opinion, this would not be a statute that would be in conflict with the IMLC. In fact, it would complement what the IMLC also does. And there's an old Supreme Court case from back in 1922 that's still good law called Olin versus Kitzmiller, and I can provide you with the citation if you need it, that says that if a state enacts legislation that is in approbation of the compact, or in other words, in support of the compact and what it provides, it is not prohibited, and that the amended language of the compact or an outside statute that applies to the compact would not be in violation of either the compact clause of the Constitution or the compact itself. So in my opinion, these sections of the bill and the bill itself is good to go in terms of IMLC and would not conflict with it. And I also don't think that it would be necessary for Vermont's representatives to seek an amendment to the compact or the rules, because I believe we already have it. So in a nutshell, that's my testimony.
Great, thank you. And so the amendment you have is specific to the Interstate Medical Licensure Compact. You're Correct. Not talking about all compacts, you're talking about that one. Okay.
No, although I think I rendered a similar opinion about the nursing compact, and I don't know if you've received any information from them, but it's essentially the same. So.
Okay. Have they also If you know, have they also put an amendment in like the interstate medical licensure compact?
Well, certainly the compact has a scope of practice provision that says you're protected as long as you're following the scope of practice. So I think the answer is yes. I'm not sure if they've implemented it specifically with a rule, but it wouldn't be prohibited if they wanted to do that.
Okay. And do you know, have any other states done this yet?
I think we are seeing a trend towards something like this, which I think is a solution that's sort of in the middle. I mean, it protects the state scope of practice so that other states that might disagree, if they want to take action in their states, then they're certainly free to do it. But it doesn't require another state to change its laws or in any way conform to some other state scope of practice, and your scope of practice is upheld under this approach. So I think we've tried to handle it, at least in some of the compacts like medicine and nursing, but this legislation certainly doesn't go against that principle.
Great, thank you. Anyone have any other questions? Great, thank you very much. It doesn't look like we have any questions right now. If you can stay on for a couple minutes, that would be great. And we're going to switch to Marshall Smith, who is the Executive Director of the Interstate Medical Licensure Compact Commission. Great. So welcome, Marshall.
Thank you and good morning.
If you can introduce yourself for the record, and then I don't know if you have any additional testimony past what Rick said. So I'm going to turn it over to you.
Thank you. My name is Marshall Smith, and I am the Executive Director with the Interstate Medical Licensure Compact Commission, or the IMLCC. I'm providing testimony regarding the IMLCC's position regarding the provisions of Senate Bill 37, specifically sections 10 and 10A. I do have a statement, if you'll let me.
Please.
Regarding the provisions of section 10, it is consistent with the IMLCC statute and our normal practice to provide assistance and resources to our member states and our member boards in understanding how the IMLCC works and the valuable service that being an IMLCC member state provides to physicians inside and outside of your state. The concerns raised by member states and boards after the U.S. Supreme Court's decision on Dobbs has been a focus of the IMLCC. We have and continue to maintain each member state's right to regulate the practice of medicine in their state and ensure that their citizens are receiving appropriate and safe care. These principles are outlined in the IMLCC statute. So the IMLCC stands ready to assist the commissioners that are appointed from Vermont in anything that the legislature would direct them to do. Regarding the provisions of Section 10A, the intention of this provision, I believe, has already been accomplished through the leadership provided by Vermont's commissioners to the Interstate Medical Licensure Commission. Currently, the regulation of the practice of medicine is controlled by each state, territory, or the District of Columbia. That control is limited to the practice of medicine provided by physicians to patients receiving care in that state. The Constitution of the United States prevents states from regulating or controlling activities of other states when acting or regulating within their jurisdiction. The IMLCC has taken a position that strongly supports these concepts. Vermont has two commissioners appointed to the Interstate Medical Licensure Compact Commission, Commissioner Gilman and Commissioner Herlihy. Both of Vermont's commissioners have in the past and continue to take active leadership roles in the commission. Commissioner Herlihy is the chair of our personnel committee and is a member of our executive committee, which is our governing body. And Commissioner Gilman serves on the Interstate Medical Licensure Compact Commission's Rules and Administrative Procedures Committee. In November of 2022, the IMLCC amended its Rule Chapter 6 by the addition of a paragraph 6.6, which reinforces and clarifies the express authority of each state to determine its decision regarding licensing actions, specifically the decision to take or decline to take disciplinary actions against its licensees. Commissioners Gilman and Hurley were instrumental in the passage of this amendment in LCCs, and both commissioners took an active role in ensuring that the provisions did change and the rule was amended. Vermont is well and ably represented by your appointed commissioners. With that said, each commissioner has the authority to introduce and request consideration of amendments to its rule. The IMLCC staff would provide resources and assistance to the Vermont commissioners to carry out the provisions of 10A if passed. This is consistent with our charge. I would request that the Vermont legislature continue its support of its commissioners to the IMLCC as they lead the IMLCC in our deliberate and active process to provide an expedited licensure process for physicians. Concerns of the Vermont legislature are similar to many other member states that have been expressed and are shared by those member states on both sides of the abortion and the gender affirming care discussion. The IMLCC was founded on the principles of federalism, where each state has the absolute right and authority to regulate the practice of medicine provided in that state, and then participate in a national contract or a compact to allow for the licensure in their state via an expedited process. Thank you for considering my comments and the comments of Mr. Master as you deliberate this important matter. The IMLCC is committed to ensuring through our commissioners and staff that member states are heard and well represented. And I am happy to answer any questions.
Great, thank you very much. And I apologize because I don't have my computer. Is that on our?
No.
Can you send that written testimony to our committee assistant so we can post it? That would be great. Thank you so much. Any questions on this? Go ahead, Leslie.
So thank you so much, and I appreciate being able to read it again because it went by fast. I'm looking at 10A, and I'm thinking about gender affirming healthcare services. And if I'm understanding this, it says services would be legal and meet professional standards at the bottom line 20 if provided in Vermont. So it doesn't address the issue of telehealth. Is that what I'm understanding?
Rick, you're on mute. And I don't know who wants to answer. So either or both of you can.
It does address telehealth in the sense that as long as the telehealth treatment is being provided to a patient in Vermont at the time the advice or care is given, the practitioner and the patient are protected from any action that might be taken as long as it's consistent with the scope of practice. So, I mean, it does handle telehealth in the sense that any licensed physician who has a license in Vermont who is treating a patient in Vermont, as long as they're doing it pursuant to the standard of care and the scope of practice, they're protected.
So if the treatment is by a Vermont clinician in Vermont, but the patient is outside of Vermont, then they're not protected.
Well, only because the compact states that the treatment occurs where the patient is located at the time of the treatment.
So can you expand on that a little bit? I think there might be some confusion.
Well, Marshall, you might want to comment on the logistics, but essentially, as long as the patient is located in Vermont when they receive the care, it's permissible, but you can't transfer your immunity by going to another state if its laws are different. If a procedure is performed in another state that doesn't have a scope of practice that extends the way that Vermont has extended protection to those having abortions or who would have gender affirming care. And I think it presumes that if you live in Vermont, you're probably going to be treated there for these issues, and that if you go somewhere else, it would probably not be for the purpose of seeking treatment.
Yeah, and if you'll let me reference specifically the IMLCC statute in section 1, which is also part of the Vermont law. When it was passed, it became part of the statute in Vermont. So in in the first paragraph of statute, section 1, it states the compact also adopts the prevailing standard for licensure and affirms that the practice of medicine occurs where the patient is located at the time of the physician-patient encounter, and therefore requires that the physician be under the jurisdiction of the state medical board where the patient is located. But with regards to telehealth or any other encounter between a physician and a patient, the license and the Medical Practice Act that is applicable to the care and treatment of that patient depends upon where the patient resides at the time they receive that care. Again, and that's one of the founding concepts of the compact is, and one of the supports that we provide is that a Vermont physician providing care to a patient in the state of Vermont, if that's telehealth and that patient is physically located in Vermont, then they would be under the jurisdiction of the Vermont Medical Practice Act. If the patient is located in another state, that state's Practice Act has a jurisdiction, and the physician would be required and is using their license in that state to provide that care to that patient. It's why the compact has become very, very popular and is a tool used by physicians doing telehealth, because they do need to be licensed where their patient that they're treating is located. And so they use the compact to obtain those licenses so that they can provide that care.
So in a way, if I understand this right, it would apply the same as in 6, which we just talked about, that the provider would take on the risk of, providing care in this state that doesn't have the same law.
Yes, and that's the purpose of having that requirement, so that every state's scope of practice is protected. And while you have a scope of practice in Vermont that your practitioners are obligated to follow, not every state has the same scope of practice, and the practitioner is responsible for knowing what the rules of the road are, so to speak, kind of like a driver's license, where you can practice in other states, but you still have to follow the rules of that local jurisdiction while you're there, and that would include telepractice.
So can I just clarify? So let's say we have a patient in Vermont and we have a provider who, through a compact license, so the provider lives in, say, Florida, but has a compact license to practice in Vermont. Is that Florida provider protected at all with this legislation?
Yes, as long as the patient they're treating is located in Vermont at the time the care is rendered, they're safe in terms of what your scope of practice provides, even if they're sitting in an office in Florida.
Florida could still go after the provider in Florida if they wanted to. It's just that no.
So in this scenario that you've created, should that practitioner provide care to a patient in Vermont using their Vermont issued medical license to practice medicine, even if they are located in Florida, it's the position of the compact that Vermont has jurisdiction over that physician and their practice, not Florida, even though the physician is physically located there. However, if that physician is treating a patient in Florida, Florida does have jurisdiction because the physician would be using their Florida license, not the Vermont license.
Great, thank you. It's helpful to clarify in simple terms. Melanie?
Just want to clarify, for patients, it's the location, not necessarily a place of residence. Is that correct?
Right, it's where they're located. So if they're on vacation in Florida, they are temporarily located somewhere else and they're subject to that state's scope of practice. But as long as they're in Vermont, your rules apply, and the practitioner is able to render the care pursuant to your scope of practice.
Thank you.
So let's use a similar example where you have a physician who's located in Vermont and is providing gender affirming care to a patient a patient comes to that physician's office from, let's say, Tennessee, and they're receiving care in that physician's office in Vermont, they are then the Vermont statute and the Vermont license are the authority by which the physician treats that patient. And you have your state board has jurisdiction over the treatment of that patient.
Okay. So, Marshall and Rick, do you mind? We still have questions, but David Hurley, he only has 5 minutes left. So can you all just hang out here for a minute? And if we can switch to David real quick. David, I apologize. I wasn't watching the clock.
Sure.
Are you there, David?
I am, sorry.
Yes, and I'm sorry. I just noticed the time.
And I can run over a little bit. That's
Okay.
fine.
Okay.
So you asked me to comment on 10 and 10A. And I think there's probably not a lot to say about 10. We're fine with cooperating with OPR to provide you all a report over a year from now about any concerns that we may have about participation in the compact. And that's fine. With 10A, I do just want to make sure that you understand that the section 10A calls on the representatives to the compact to seek amendments of the compact, and I just want to make sure you all understand how difficult and unlikely a scenario that would be. I mean, certainly, I'm not saying that we wouldn't try, but compacts are, by their essence, they are not an a la carte menu. Compacts are, it's all or nothing. To join the interstate compact, you need to accept every provision of it and enact that in your law. You can sort of put in some enabling provisions that add to it within your state as you operationalize the provisions of a compact, but you're stuck with the compact. So I want to make sure that nobody has any false expectations about what might be able to be done. We're up to, I think we have 38 states now have enacted the compact, and there's a couple more that look like they're probably going to pass it in the near future. There's 6 states have introduced it, so we're getting close to every state being in on it, and it would take all 50 states to simultaneously change their laws if we do get to every state having adopted it. So I just wanted to make you aware of that. The other thing it talks about is trying to influence the bylaws and the rules of the compact. And thank you to Marshall and Rick for your kind comments. And yes, we did work to change some of the rules, and there's work still ongoing. The process doesn't happen overnight like the Vermont process for enabling rules. It takes time. There's a process for sharing them publicly and accepting comments, and then we have to have a meeting of the full commission in order to change the rules. I do just want to give you a little bit of background. There's nothing inherent in compacts that says we want to have rules or standards that force states to accept actions by other states that they don't want to ratify or don't want to be involved with. When the compact was put in place, I think that there was a big concern on the part of many potential members among the states that by taking on these positions without going through their regular licensing process, they might get stuck with bad actors and have some difficult cases to deal with. And so one of the I think features that was included was provisions that sort of say, listen, if somebody does engage in bad conduct and gets sanctioned for it, then it's going to be easy for you to address that. And that was the focus at the time. And before, Vermont was a fairly early adopter of the compact, but there was a few years there where we weren't, a couple of years where we weren't on board, and the rules were put in place. And I can't speak to what the discussion was at that point, but with the Dobbs decision, there was a new perspective on it. And when everybody read the rules, it was like, oh my gosh, the worry went from, not from, what are the challenges in taking somebody out of practice within your state who's engaged in bad conduct, but it changed to looking at it through the lens of, okay, so what if somebody engages in conduct in another state that is sanctioned by that other state, but we don't think that's a reason why they shouldn't be licensed here. And so, again, it's not an inherent feature of a compact that you're going to be put in that position of having to act upon other state sanctions in regulating your licensees. So, as Marshall mentioned last fall, it was the rules were amended to make sure that we wouldn't have to take any formal action against a licensee to the greatest extent possible. It now does say that a member board authorized or required to impose an automatic licensing action against the compact physician under 10B and 10D may immediately terminate, reverse, or rescind such automatic action pursuant to the Medical Practice Act of that state. So in other words, the compact rules and the compact law, now potentially we could have a situation where there was technically a temporary suspension, which effectively could be as short as 1 minute, and then we could provide that such actions, if in conflict with our laws and rules regarding legally protected healthcare activity, would be automatically rescinded, so that there would be no impact on the licensee. I just wanted to share that with you to make sure you understand what the current situation is. There's another aspect of the rules which has to do with the information sharing and cooperation in investigations. And there's a proposal being reviewed and going through the process now, which should allow us to avoid any instances of having to turn over information, cooperate with an investigation in instances that are in conflict with the concept of legally protected healthcare activity. And in short, that makes all the requirements for cooperation come into place only if the state elects to become part of a joint investigation. So we'd be in the driver's seat as far as that goes. So, the good news I would say is that we're fine with what you call on us to do. A lot of the work has already been done, and we are hopeful that those additional changes will go through, and just subject to those. I hope that you have better understanding now of what reasonable expectations are for changing the compact. Other than that, we would be willing and able to work with 10 and 10A as presented.
Great. Thank you for that and for the explanation of how it all works. So any questions for David before he has to go?
Yeah, he didn't do any written testimony, so I was wondering if that's reasonable to ask for?
Can you provide just a written statement of your, I don't think you have to go through all of that, but at the end you said you're fine with it and a lot of work has already been done.
But the salient points you want us to know.
Sure.
That'd be great.
I probably won't get it to you until tomorrow because I'm about to leave for a board meeting for the rest of the day.
Yeah. I think we're good. Thank you very much, David. Enjoy your board meeting.
Thank you.
Thank you.
And we're going to go back to Rick and Marshall. Lauren, if you're okay hanging out for a little bit. Okay. So, Art, I think you had a question.
Yes, and I can pick it up where we left
Great.
off. I'm pretty sure. Marshall, you were talking about the person from Tennessee who came to Vermont, had services, and thus is protected. If he goes back to Tennessee and there's follow-up, or, okay, is he protected then, or must all that happen here? So he's here for, say, a day or two. He's working, he or she is not able to stay through the whole period or procedure. He would then go back. What's the rule on that?
That is one of the concepts, especially as it relates to telehealth, that has still been untried and untested. But the concept of applying the basic concept that we have, that patient would need to come back to Vermont for their follow-up care.
Gotcha.
So they are receiving care in Vermont. There are. As I said, it's not settled at this point, especially as it relates to, the traditional model, of course, was you had to go physically back to get your pre and post in care, because that's how it was provided. In the world of telehealth, it is, as I said, an unsettled matter. Right now, it would appear, and again, letting me put all the caveats in the world on my statement, but it would appear that the patient, when they go back to Tennessee, if they're going to continue post-care with that physician, the physician would need to be licensed in Tennessee, and the Tennessee license would prevail over that post-treatment care.
Okay, thank you.
Mm-hmm.
Any other questions at this point? Great. We're going to bring Lauren up from OPR. Again, do you mind staying on Zoom for a couple minutes in case there's some more questions? That would be great. Thank you.
Fine.
Lauren, welcome back.
Again, Lauren Lehman, General Counsel for OPR, for the record. I'm here to talk about sections 10 and 10A. I'll start with 10. We do have one minor request for 10A. I'll start with 10A. We do have a minor request for 10.
Okay.
And I'll hop back to that.
Okay.
So as you've probably heard, the intent of the 10A is to allow or instruct, so direct OPR and the other representatives and delegates to the compact commissions to pursue amendments or changes to or interpretations of the compact that we do not need to discipline licensees from other states for engaging in activities that are consistent with our laws, those activities being gender affirming care, reproductive health care services. We fully support this, as our folks online have testified. OPR through Gabriel Gilman And working with David Herlihy, pursued a change to the IMLC compact this past fall in response to the Dobbs decision. And I think consistent with what David testified to, the issue is not so much where the scope of practice applied. It was if you have that Tennessee example, for example, if that person comes to Vermont and receives their gender affirming healthcare here, returns to Tennessee in the Vermont and does a follow-up telehealth visit with their Vermont provider, their Vermont provider is subject to the Tennessee scope of practice. And so that Tennessee could then take action against the Vermont licensee's compact license or home state license. Sorry, I'm reversing this. If they had a license in Tennessee, they could be disciplined for providing that care, and under the Tennessee law. And the agreement with the compact is if a home state license is, and not just IMLC, there's variations, but under all the compacts, the agreement is if there is discipline against the home state license of a licensee, the remote states also have to discipline that license. They either have, in many of them, they have to revoke the license. They no longer have a compact license or ability to practice here. The solution that the IMLC reached essentially was you, remote state, can transition that compact provider to a home state license, to a full state license in your state. So you no longer, that Tennessee provider no longer has a Tennessee license or a compact license, but Vermont can transition their compact license to a full state license in Vermont to allow that Tennessee provider to continue practicing here. That's the solution we would probably seek in other compacts as well. So really the issue is this, what we've been calling reciprocal discipline. It's somebody's disciplined, their home state license disciplined under that state's law. Does Vermont then have to discipline that licensee as well by taking away their compact license here? And the solution is we have to take away their compact license, but we can transition them to a full state license here to practice.
As long as they qualify.
As long as they qualify and they maintain,
And they wish to.
and they wish to.
Yeah.
Right. Again, there's some responsibility on the part of the provider to know where they're practicing and to understand the ramifications of their actions. But it doesn't require Vermont to then prosecute somebody to revoke their compact license using the laws of another state that are contrary to our laws. So that's the solution here. And that's what this directs. And I think 10A directs OPR and other representatives or delegates to the commission to pursue. And we're comfortable doing that. We do, to David's point, a small technical correction, we would add to the directed activities what we should seek, maybe a compact rule, because as he noted, an amendment to the compact's not permitted, but amendment to rules or bylaws may be another solution and another way to address the issue in other compacts. And another potential option would be to develop a compact rule addressing the issue. So just include that as an option.
So would that be in 10A or 10?
10A. So that would be, it says Vermont's representative or delegate for an interstate compact or agreement related to healthcare shall seek, currently it says shall seek an amendment or exception to the compact or agreement language, rules, or bylaws as necessary. We would add in shall seek a compact rule or an amendment or an exception to the compact agreement language, rules, or bylaws as necessary, just to give us another option or directive. I think it tightens it a little bit, but I can.
Okay, we're going to have you work with Cameron as well. Okay.
Yeah, I'll work with him on that.
Okay.
I clarified there was another, so we are fully supportive of it, but there's some technical corrections. I clarified in the written testimony, I'd noted that rather than using the term legally protected healthcare activities, the two separate terms, gender affirming healthcare services and reproductive healthcare services, were used. Confirmed with legislative counsel that was intended in order to cover those who are not licensed here.
Okay.
Within the definition of legally protect healthcare. So I withdraw that.
Okay. So you're fine with the language as it is. Okay.
And then we recommend another change because it says, and applicants from other member states seeking to practice a profession in Vermont are, let's see, it says that.
Are you still on 10A? Sorry.
Yes, 10A in there, it's the second full sentence. It says, therefore, it is the General Assembly's intent to protect the ability of professionals licensed, certified, or registered in Vermont and applicants from other member states seeking to practice a profession in Vermont pursuant to an interstate compact or agreement. My understanding is the intent is to protect not the applicants, but the actual licensees practicing here in Vermont or seeking to practice in Vermont under the compact. Rather than the applicants to do so.
So if they're seeking to practice though, wouldn't that be an applicant?
They would already be licensed, but they, because it's a compact, they're already licensed. So that's the only reason I would change that.
Okay.
They're not applying to practice here. Under compacts, they're already authorized to practice here.
So I'm going to have you talk to Ledge Council on that one as well. Okay.
So that's all I had for 10A. Very much support it.
Can you just stay there for 1 second? And I want to make sure everyone's clear. So 10A is specific to all compacts we might be entering into versus 10 is specific to the interstate medical licensing compact.
And nurse licensure.
And nursing too?
Yeah.
And nursing too. Okay. Yes.
The record, Amber Virginia Legislative Council. Section 10 is the results, to address any concerns regarding the state's participation or contemplated participation in interstate licensure compacts, including the state's participation in the 2 current compacts. So it's more than
just those 2. Okay.
Yes.
That's helpful. Thank you. Because I was like, what about all the other ones that we've just passed out of here that we might be getting further? Specifically, the counseling one is what I was curious about. Okay. Okay, 10.
So 10, we're very happy to do the report and to work with the Board of Medical Practice. We do have 4 other reports due in the next 18 months, including an expansive mental health study that we're supposed to do. We also have optometry, a numbers report on the nurse licensure compact, and a reflection on massage therapy licensing. So we're happy to do the report, but we would ask that it be extended to November 2025. I think that'll better reflect and give us time that many of the compacts aren't going to be starting in Vermont until next year. So that'll give us more time to gather data and information as well on concerns and impacts. So if the committee's amenable, we would like that extra time.
Right, because I think most of the compacts we just passed out of here are a 2024 start, right?
July.
Okay. So does anyone, we'll talk about it later, but first grasp, is everyone's okay with that? I'll make a note of it. Okay.
The first line you're talking about.
Yeah.
Okay, so November 1st, 2025. Okay. Great. Any questions for Lauren?
Thank you all.
Good, thank you. Any final questions for Marshall or Rick?
Well, I applaud the effort to make this issue one that's more manageable, and I hope you can share this with other states who might benefit from it also, because I think this truly is a solution for some of the problems that have been caused by the politicization of healthcare, which we wish didn't exist, but it does.
Yeah, thank you for that. And thank you both for spending your time with us. It was extremely helpful to hear your perspective. So thank you very much.
Thank you.
Thank you.
And thank you. And I think we are done until